There we go. All right, our meeting is now being recorded.
Still Mike's coming.
And everyone that is joined us on Zoom, you should be able to hear us. Hopefully you can. If there's a problem with the audio, please let us know. Mike, oh, there you are. I knew you were here. Mike Cannon, our Director of Zoning. Mike, if you would please call the roll.
Mike Tablet.
We had three total. Say here.
Mike Tablet.
So you
Oh,
guys-
sorry. Here.
You don't have
Silly Nancy.
here.
Bruce Salmon.
Here.
Ray Lewis.
Here.
Tom Mead.
Here.
Tom Church is not here.
We are scheduled to have two hearings tonight. The first one is scheduled to start at 7:30. It is for a new article for the zoning resolution, Article 31, Plan Unit Development, Mixed Use Overlay District Procedures. The copy of this proposed new article has been and is available online on the district website, as is also the second article. As we begin the meeting, the procedure that we will follow during the hearing, I will ask for review comments from the zoning commission members. At a point, there will be the opportunity for public to participate. We will provide that public opportunity. And once the period of time has expired for the public participation, we will close the public participation and go back to discussion by the zoning commission members. At this point, Mike, do you have a copy of the art of what the public announcement was, or in the newspaper? Okay.
If you give me a second, I can pull it up on
Can
the
you
website.
pull it up so we can read it into the
Yes.
minutes?
You could have asked the online viewers to state their full names and addresses.
Yeah, we'll have to do that if they're,
I got him. I got him.
Mike,
but
Holly has it.
Holly, you have a question?
No, I let the person in if that's
Oh,
what you're
okay,
trying to
thank
do.
you. No, I'm
Got you.
used it to keep things started and then got to bring it back.
Oh, we're loading very
All
slowly.
the online folks that are joining us on Zoom. Mike, will you take a sheet of paper and make sure you record all the people that we've got online? Anyone who is been admitted, and it just shows your phone number or some other call name. Would you please identify yourself by full name and give us your address? We'll be recording that. It'll come in, it'll be recorded audio wise, but then we also want to have that as part of our minutes for the hearing.
Are you ready for this to be read?
Are you ready for, did you find it?
Yeah.
Okay, yes, would you read that, please?
The Harlem Township Zoning Commission is being asked to consider the following. The Harlem Township Strategic Planning Committee is requesting that the Harlem Township Zoning Commission consider amending the Harlem Township zoning resolution to include a new zoning article. They are recommending that a new Article 31 Planned Unit Development Mixed Use Overlay District Procedures be adopted as part of the Harlem Township zoning resolution. And there is a link to that those procedures. The hearing will be held on Monday, April 24th, 2023 at 7:30 p.m. at the Harlem Township Firehouse, 3883 South State Street, 605 Galena, Ohio, 43021. The hearing is open to the public. The proposed article can be viewed by appointment only. please contact the zoning office between 8 and 12 at 740-965-2661, extension 2. The zoning hearing will also be available via Zoom. Mike Chair, Mike Kavler, Chair.
Can we also read the one in for 34 as well?
I'm sorry, I couldn't hear you.
Can we also read the notice in for Article 34
Yes.
as
Oh.
well?
We will when we open that hearing. They are scheduled as 2 separate hearings.
Okay.
And right at the moment, we're dealing with just the first first article, which is the article dealing with the procedures. But we will come back to and when we recess this hearing, we'll open the other one and then we'll go through the same process of reading that the announcement that was the public notice that was in the Delaware Gazette. Okay. All right. You heard it mentioned that this is a recommendation that came to us from the Township Strategic Planning Committee. And there are some members of the Strategic Planning Committee present here tonight. And I will introduce them and any other officials that I recognize out there. Holly Matai is a consultant that's been working with the zoning commission I'm sorry, not with the zoning commission, but with the strategic planning committee to put together these articles and to bring forward then the recommendation. So Holly is here tonight. She can answer our questions that we may have about this as we go through the proposed article. The other person sitting next to her is Molly Ridge. Molly is working also on that with Holly. And then we have members of the Strategic Planning Committee. Jim Steelsmith is here. Steve Eisenbrown sitting over there.
Bruce McClary on there. On
I
Zoom.
beg your pardon?
Bruce McClary on Zoom.
Is Bruce on Zoom? Okay, Bruce McClary is a member of the Strategic Planning Committee. Tom tells me he's on Zoom. And let's see. Okay. I guess that's all. I don't see anyone else. Okay, with that, then let's start the process. We'll go through what you're seeing up on the screen is the article that we are dealing with. And as we progress through this, Holly will simply be scrolling through the pages as we go then.
Can I go through it and describe it to you?
Yes,
Okay. Is that okay to do now?
let's get started.
Okay, great. So I do want to mention that what is in front of you on the screen and what is in front of the zoning commission members is the draft that was issued on the website with the legal notice. So that will be what we are referring to as ZC-draft 1. Meaning this is draft 1 of the zoning commission. So there are other drafts that have been created that went through the strategic planning committee. So I want to make sure we're not getting confused with old drafts versus what's going through this legislative process. So that's why I'm very particular in labeling these ZC draft 1. So that is what we are starting with tonight. Any changes that are made after this meeting tonight will then be put into another draft. We'll label it ZC draft 2 for your next meeting, and you'll accept that into the record and continue on as necessary until you get to the point you're making a recommendation to the zoning commission. In addition to the procedures, there is also a definition section that is going along with this. So it's important that we make sure that we're including that as we move forward in the review of these overlay districts.
And that has also been made available online.
Correct, yes. Correct. All right, so having said that, the procedure for the mixed use overlay districts, we have indicated that this is following ORC 519.021C. which is an overlay district. It is the kind of overlay that, or kind of PUD that serves as an overlay So the existing zoning that is underneath the overlay will continue to apply to all properties. And then if a landowner wishes to move forward with the mixed use overlay district, they would come to you and follow these procedures to pull down the cloud is the term that we use. It's informal slang term, but they basically pull that mixed use overlay district down. And if they follow these procedures and get approval, at that point in time, the zoning would change on the property. What is important to note is that when we go through this process, the actual rezoning in the text takes place with the adoption of these text amendments. That is the referendum period. After that referendum expires and somebody pulls down the cloud, that is not a legislative act, that is an administrative act. So that is not referendum at that time, cannot be referendum at that time. So let's talk about what the procedures are to get approval of a mixed use overlay. The first thing that an applicant will do is they will request a pre-application meeting. These are informal consultations with the staff from the township, and the township can also request the Delaware County Planning Commission, the county engineer. They can request up to 2 members of the zoning commission to attend if they want to, or other departments prior to the submission of the full development plan. We go on to say in here, and this is language that we use throughout the state of Ohio and these types of overlay districts, that no action should be construed as an actual commitment by the township. And then if there are more than 2 zoning commission members present, or more than 1 trustee present at any of these meetings, you still have to follow the Ohio meetings law, sunshine laws. But most of the time, the applicants and the townships keep it under those limits so they can have some informal conversations outside of that public meeting setting.
Holly,
Yes.
since you and I didn't talk about this procedure before we started the hearing, I just want to make sure that I think what the strategy you're following is you're going to go through the document, then we'll come back and the commission will begin to share with you any questions or changes that we want to deal with.
Yes, if that's okay with you.
Yeah, no, I think that's good to help the public get a good
Yep.
picture.
Good, perfect. So the next step after the informal meeting would be the applicant would apply for what's called a trip generation and connectivity memo. This is actually something that would be generated by the Delaware County Engineer's Office. We've had conversations with the Delaware County Engineer's Office that they would like to ensure that applicants are meeting with them upfront prior to or during the rezoning periods before they actually get to them for the design of their subdivision. Because sometimes it's too late if they get too far down the zoning process to get the types of connections that they need or the types of improvements that they need for those subdivisions. So this gives an early pulse check with the Delaware County Engineer's Office. At this time, if there's a certain threshold met in traffic counts, the engineer's office could request a full traffic study to be submitted, but most of the time, this is going to be more of a high level determination to make sure we're getting connections between subdivisions and making sure that we're getting the internal circulation that makes sense for the community so that we don't have people cutting through subdivisions. We don't have people also on the same other end of the spectrum having to keep going out to the main roads, that we're creating that connectivity. So that's what the purpose of this memo is. If they get through that step, then the applicant would actually file for the actual development plan approval. This will be the first step in the formal process to go through the approval process. The development plan includes a list of several items, and it starts with 4 main items regarding the survey, the grading plan, and then open space maintenance requirements. And then also, if a traffic study is required, this is when the traffic study would be submitted. There's also language in here allowing the county to hire a third-party engineer to review any of the traffic analysis or connectivity requirements of the Delaware County Engineer's Office. That way you can get your own perspective in addition to what maybe the county engineer's office is saying. So that this gives you the right to do that. Then the development plan contents, I'm not going to go through all of them. I think there's like 38 of them, but it basically outlines that you have to show that the developer showing that drainage works, the water and the sewers working, floodplains, all of the ins and outs of what a development plan would typically require. When we get to the actual requirements of the overlay, it is going to require that central water and sewer be provided in order to utilize this district. So item number 16 indicates that the applicant has to have a letter from the water and sewer districts saying that they have sufficient capacity to serve the proposed land uses. Another high level to point out is the color renderings have to be submitted. We have a lot of architectural requirements in these overlay districts, so making sure that we have renderings with color coding and understanding fully what those are going to look like is important. I also want to point out item number 25, a sightline diagram. This is a diagram that we've required in other communities that will show what an adjacent residential lot would be looking at when it's abutting this commercial mixed use. So what it shows a person standing at 6 foot tall on the property line, looking at the commercial from their residential property line. And it's a rendering, so you can kind of fully understand what that's going to look like. Lighting plan, landscaping plan, parking plan, sign plans, all standard stuff. Item number 33 does point out that a funding plan needs to be submitted that identifies any TIFs, JEDs, NCAs, or other economic development tools that are being proposed to help move the project forward and to help maintain things in the long term. When I get to the end of this, I'm going to pass out a few recommendations that a legal counsel has. I have my own legal counsel that I had review the document, and he has a couple of things where we can beef up this language to make it a little better. So I'm going to expand upon that when I get to the end of this. Once the development plan is prepared, it is then submitted to the zoning inspector, and the zoning commission schedules its public hearing. And the zoning commission has 30 days from the filing of the complete application to schedule and hold that public hearing. The zoning commission would be required to give the 10-day notice in the newspaper, and then also to the adjacent landowners surrounding the property. Once the public hearing has been closed, then the zoning commission has 30 days to take action after the conclusion of that hearing. And then one of the important things that the strategic planning committee really focused on is that once it comes out of the zoning commission for a recommendation, it goes to the trustees, but it's not going to go to another public hearing. It is just going to go to the next regular scheduled trustee meeting and be received and acted on in that same night to help expedite the process of moving forward. The basis of approval for this, there are several different criteria. Making sure that every criteria and every intent behind every criteria is being met. The language in the code does allow for divergences. But if there's a divergence, the applicant has to list it out of why they are diverting from a particular item and give an explanation. And your approval has to be based on that deviation is something that is necessary for the benefit of the community and of the development. The other criteria is whether or not they meet all the design features, whether the proposed development is compatible with the existing land use character and the intent of the mixed use overlay. If it's adequately served by roads, walkways, bike paths, police and fire protection, central water and sewer. So that's key because you do not have the sewer yet, but it's coming. So we want to time the development with the sewers. We don't want somebody trying to pull this down and trying to do on-site systems. So that is key with that. And then again, item number 7 indicates that an adequate funding package for the construction and long-term maintenance of the required open space and community improvements has been provided. That is another area where the my attorney has beefed up that language for you. So I will be going over that as well. But he does feel like you can absolutely make that a criteria of plan approval. Drainage, making sure that it does not negatively impact surrounding properties is also a criteria. And then you as a zoning commission or the trustees can impose additional conditions and safeguards as you deem necessary to make sure that the public health and safety are being carried out. Once it's approved, so what G is saying here is once it's approved is what I was explaining before, that it's actually pulling down the cloud. That is not a legislative act. It is an administrative act, and in changing the zoning map to MU overlay is just a ministerial act at that point in time, and it cannot be referendum. And then the next item is plat required. So if a plat is required, then they are subject to going on to the Delaware County Regional Planning Commission in accordance with the Ohio Revised Code to get a plat recorded. This section also says that no zoning certificate shall be issued by the township until such time that plat has been recorded. And then I indicates that the development plan approval is for 5 years, and that's to allow time for that plat to be recorded if a plat is required. If the construction has not commenced within that time frame, the 5 years, then the approval becomes null and void at that point in time. There is an opportunity for the applicant to ask for an extension, and that would be granted by the Board of Trustees. So those extensions would not come to you as it's currently written. It would go straight to the trustees, and they would have to justify why they need that extension of time. Once a development plan is amended, so I want to make sure this is clear. Prior to the development plan being approved, if an applicant wants to deviate from a standard, that's what's called the divergence. So that's before a development plan is approved, and those get marked down. And if they get approved, they become the standard for that development. So if the setback's 50 feet and they ask for a divergence to 45 feet, that's what becomes that approved standard. If they want to do something different outside of the requirements after the development plan is approved, then there are 2 ways they can do that. There's what's called minor amendments and major amendments. Minor amendments are things like shifting a setback by like 5 feet or less, or changing a sign face but not altering the size, height, or setback of the sign, or changing the building height by a couple of feet, no more than 5 feet. Reason why we do these minor amendments is because grades and those sorts of things can change from your original preliminary development plan to getting out and actually constructing. So a couple feet here and there is not, it's very common to see that. And to have to bring an applicant all the way back through that process for a couple of feet is very cumbersome. So we typically write these in as minor amendments, and that is allowed. With the minor amendment, the zoning inspector is allowed to grant those amendments. And he has 30 days to do that from the date he received it. If someone is aggrieved, feels like the zoning inspector did not act accordingly to that request, it can be appealed, and that appeal goes to the Board of Trustees. And then if that action if someone wants to appeal that action, the township trustees action gets appealed to the courts at that point in time under 2506 of the Ohio Revised Code. Any other amendment, so amendments to open space, density, major road layouts, those sorts of things, anything that's not listed in items 1 through 4 here as a minor, anything else is a major amendment. And that has to go through the whole development plan process again. So they're coming to see you, through a public hearing, and then going to see the trustees. And then once the trustees take their action on a major amendment, the appeal would go to the courts at that point in time. And then last but not least, there will be a fee that the applicant has to pay to get through this whole process that should cover all of your review fees. So that is listed here. So that's the last of the procedures, but what I want to do is pass this out to you. Do you mind passing this out? Thank you. These are the things that our attorney would like to see you add to the procedure section.
I have a question. It's Holly, right? Holly, who are you with?
I'm with Crossroads Community Planning.
Crossroads Community Plan?
Mhm. So the first change that the attorney is recommending is under C. Where it talks about applicable fees. He just wants us to add in accordance with this article. That seems minor, but the reason why he wants that is because when we go back down to actually, it's not here because you have it, it would be added in. Under C, the new D would be what you see there in red. It would be fees. And it's a big, long paragraph, but it basically allows the township to assess an additional fee to cover consulting fees if you want to hire a consultant to review development plans and provide comments to you, or if you want to hire an engineer to review the traffic analysis. So those sorts of professional fees can be covered under this additional fee. And it allows you to increase that and ask for additional fees if they're getting low on those review fees. And there's a time frame for doing that and a process for doing that, which is all spelled out in what he has sent us.
Glad to see this. One of the things I was gonna ask him, how to. I didn't know what the language should be,
Mhm.
but I was concerned that that wasn't in there.
Yeah,
somewhere.
yeah.
So this is good.
Yep, great. Then under development plan contents, everything would be relettered and the development contents would be E at this point. And then he wants us to add in between 36 and 37, it would be a new number 37. Stating that an executed acknowledgement from the applicant requiring that all real property put into a commercial or mixed use be placed in an existing JED or a new JED in which Harlem Township is a contracting party in accordance with the provisions of this section. So my 33 that I have up there still stays. So they still have to give you a funding plan of how they're funding everything. But then his 37 says you have to also join a JED that Harlem Township is a party to. And then going down to what is F on here, which would become G because of the relettering, he wants us to add in an additional condition of approval, which basically says if someone chooses not to join a JED, that you can deny the development plan because they did not follow the criteria that was they were subject to. So that's how we're bringing that JED in. And he feels that these have been put in other townships and have been, he feels that it's legally defensible. So that's what I have.
Are we going through the definitions at the same time or are we doing that separately?
Yeah, I mean, I can go through them. There's really, I mean, I don't,
They're pretty self-explanatory. I
Yeah.
just wanted to see
Yeah.
if we're.
yeah.
doing
So
this.
if you have any comments on the definitions,
Okay.
yes, go ahead and we'll take them, but I don't think I need to run through the whole thing.
I didn't, and the procedures, there aren't the hot links aren't present that I saw.
Correct, not,
But they are in the other
Mhm.
article that we will be considering. So we can review them as we go through that. Is that all right?
Yeah.
So.
I did have a couple of items on the definitions, though. Not happy that under retail businesses is included guns,
So you've included what?
guns.
Oh, okay.
And your definition of lot differs from what our definition of lot is in our current zoning code.
And I'm having trouble hearing you tonight. I'm so sorry. Please say that again.
The definition you provided for lot is different
Lot.
from what our current zoning code has.
Okay.
And we take like a page of different parts of lot to describe them. And I think it might be confusing if there's two different
It would be.
definitions of lot.
We can probably just take lot out of here because these definitions are going to go into your definition section. So if you have, we don't need a definition of lot. We'll just use your definition.
Okay, and under your mixed use building / development. It may be better to separate mixed use building and mixed use development. Because it didn't make sense to me that last sentence you have. Mixed use buildings / developments must have dwelling units on the upper floors and commercial uses on the ground floor. If you're talking about a mixed use development, that might not be true of every building.
Sense. Yep. I agree.
I think that's all I had for the definition section.
Well, we were going to go through each of them as we got to the other articles. So if anyone else has a comment at this time, since we're doing it and Holly's making the recordings, that's fine. Go ahead and point it out. Otherwise, when we start on the next article, Holly, we can go through the definitions. Not word for word, I don't mean, but
Right.
just identifying what's there
Mhm.
for the public. Okay. So now I guess we're ready to go back to the beginning, so to speak, and start through the article in terms of any questions or comments from the zoning commission members at this time.
So
It's closed to the public.
I do have a comment. I think 8 o'clock, we were supposed to start the next one, so if we can. Wasn't that? With the way we advertised it, we were supposed to start.
Yeah, we're supposed to start at 8 o'clock and we're like a bus line. It's okay if we're late, but we can't be early.
Okay, so we don't have to.
We don't
close
have to
the-
literally start it at 8
Okay.
o'clock. We could do that if for some reason you think it's appropriate to recess and deal with the other one and then say we're coming back to this one after we go through Article 34. But I thought we would go ahead and start through this one and then start the other hearing late. But if the preference is to start the other hearing now and recess this one,
Yeah,
how far we'll get in
No.
that, and then we'll come back to
My
this
only
one.
thing is I don't necessarily want to only get through the procedures tonight because we do, for the first time in a long time, have public in attendance. And so I think they're probably going to have more comments about the bulk of the district, not the procedures. And so I think it is sensible for us to make sure we get to that.
Yeah.
Well, I'm not saying you don't. I'm
No
just saying I
public-
want
no
to make
public,
sure we get
please.
to both.
Keep your comments until you're asked for public comment so that we can control the meeting and deal with it the way I need to be able to hear what she's suggesting that we do.
So I'm okay with continuing for this. I just want to make sure we do a lot, at least
Oh,
sometimes to
no,
get
I
to the
was
others
not
as well.
planning on us just recessing and not dealing with the other. I think we need to go through the other document at
Okay.
the very least.
As long as there's sufficient time for that as well,
But
then
if
I'm fine going.
We
through
have
this.
to make a choice of whether we go ahead and recess to do that, go through the document, then recess that and come back to this one.
No, this is fine.
I don't know how far we'll get, how late do we want to stay? So let's start through this and we'll see what kind of progress we make. Maybe we can get this wrapped up fairly quickly. I don't know. We'll find out. All right. So going through the procedure, starting with the first thing that I want to identify and point out is that the outline in terms of the enumeration that's utilized, there need to be a lot of changes made in that so that it matches up with the standard format that we use with all of our other zoning articles. And on this one, you start off with section 31.01 purpose. And then it just lists by alphabetical after that point, but each of those letters should really be like A should be 31.02. B should be 31.03. And then 1 should be capital A. That then will bring this structure in line with all the rest of the articles. We spent a lot of time addressing that like 3 years ago to try to bring about consistency. So I want to make sure that we bring this one into the same format.
Sure,
I
absolutely.
mean, we don't have to go through each one
Right.
because it's following that structure.
Yep. I got it.
Okay, with that said, then going back, getting to the specifics, which would be paragraph A will become 31.02, but comments with regard to the pre-application, is there something in there that anybody had a question about? I have a question about something, but go ahead, Joni. I'll let you do yours first.
Yeah, because we've recently been working on Article 13, our current PRCD, and we've been talking about that procedure. I wanted to know about the on-site meetings with the zoning commission.
So.
It doesn't mention on-site in
Sure,
here anyway.
It doesn't. So the conservation districts, because those are preserving 50% of the open space and then clustering the other 50%, it makes more sense to have the on-site walkabout and understanding how that lays out. Mixed use only requires the 20% open space, and it is more of a commercial mixed use, developing the land more than it is clustering and creating that design. It also is the district where we are up against the Columbus pushing forward. So we need to make sure our procedures are in a form that will allow development to move through the pipeline, be scrutinized by the zoning commission and meet the standards, but make sure that we are moving it through the pipeline. Otherwise, I think that potential for annexation into a quicker process could be a threat.
I had a similar question as to why it was left out. And
That is why.
then the other,
I also was
ahead.
wondering about the use of the consultations may include, representatives from the zoning commission as well as these other things. I think they really need to include.
And I agree. And most of the time they will be, but as soon as you hit shall, if somebody doesn't show up, you're violating your zoning code. So may is in there to be a little more flexible as you move forward.
I'm just worried that it also includes the possibility that they don't have to contact anybody for any consultations.
And if they don't, they bring us a crap application, then goodbye, non-refundable deposit.
Well,
I
but
mean-
you're saying the applicant.
there's
shall
no
engage.
application yet. Under this is pre-application meeting. So there's
Yeah,
no
what I'm
fees
saying is
been
if they
paid.
don't even do that and then they try to continue on, they're not doing themselves any favors, and hopefully the next person will learn. So
That brings me up to the other question I had about that paragraph, because at the end of the paragraph, it makes reference to the application should provide a conceptual layout of the proposed development. but this is a pre-application meeting. So I'm a little bit confused about why we're making reference to an application here.
It should say the applicant should
Should-
provide.
Yeah, it's it's a typo. It should be applicant.
Okay,
Is that okay?
that makes more sense to me. I couldn't
Yeah.
figure out how to do that. When, having an application when in fact the application comes later.
No,
All right.
I think we all agree that it's kind of, it was backwards.
Yep.
So. But the applicant should provide a conceptual layout, and I think that's
Well,
the
that's what
first
I've,
step in the informal consultations. What do you want to do?
Yep.
Let's see what you want to do.
yeah, because that there has to be something that the informal group is going to be able to have an understanding of what is being proposed. So it should read the applicant.
Yes.
On that page, I just have minor things which aren't worth spending any time.
Yeah.
What we'll do is once we get the second draft,
Hmm.
I can redline it. Everybody can see,
Yep.
changes in spelling.
Yep.
Now, the other issue I had with things is I think we have to require at least one preliminary meeting with the zoning commission, just like we do with every other planned district.
I think you're going to slow the process down and you're going to open yourself up to the threat of annexation.
I don't think that's necessarily true for something that important. It doesn't slow anybody else down all that much. And they come in with a better development plan.
I think what Joni's referring to is the process that we've been following. And then, when we say staff, at this point, we've got Mike.
Right.
So if we're, at this point, I'm not sure, we're dealing with a whole new conceptual idea here for Harlem Township.
And so, Joni, what are you seeing as the key differences between this pre-application meeting and a preliminary meeting?
Yeah,
I'm
'cause
seeing a huge difference between it.
I think she wants a meeting with the zoning commission,
She
not
wants to
with
meet with
staff.
the zoning commission.
Just like we do for every other planned district. We require, and we talked about this with Scott Sanders at our last meeting, and he agreed that.
I
We
agree.
changed it from should have to being required.
I agree for the conservation districts.
I think it's true for every planned district. I mean, we have it for our planned commercial district. And we have required it for our planned commercials.
But we're not out of the loop. We're just later on, and
It's completely different.
we still have a say. We still approve it or not. We can still make changes to it or not.
Mhm. Yep.
We get it after.
If we have a preliminary meeting, we tend to end up with a better development plan afterwards that goes much faster.
That may be true, but what we have here is a conceptual meeting, consultations, whether we're included or not, you can't get around us. You have to bring the development plan to this commission. And if it takes 3 or 4 meetings after the application is made, it's the same as 3 or 4 meetings before the application is made. It's,
I just don't see why there's any balking at something that we've decided is necessary for every other planned development.
I think this is essentially a different kind of plan development. It's not a
I think
residential
this-
conservation with a lot of.
It
open
is,
space.
it is not, but it is even more concerning to me because we're opening up a lot of area, a lot of density.
So
So I think it is even more concerning that we have preliminary meetings on these.
So with the overlay district, either they meet the requirements or they don't meet the requirements. There's no negotiation. So having meeting after meeting after meeting isn't going to solve anything. Either they're meeting the regulations or they're not meeting the regulations.
And they have to come to us with a divergence.
Yep.
That's done after the application is made
Mhm.
with the development plan
Correct,
and divergence is
Correct.
spelled out.
correct.
I mean, I'm willing to leave this as an open issue
Mhm.
until the next
Sure.
meeting.
Sure.
But we're included somehow in the conceptual
I also think just like any other district we have. You know, we haven't done it before, we'll try it, and we might see that there's some things that need tweaking, just like we did with. With the PRCD that we just did, we saw some things in our code that were like, that needed adjustment, it didn't work how we wanted it to, so I think. I mean, clearly Holly's done these before, I think there's some sense. Trying it this way, seeing how it goes, and you know, we are in control of the zoning resolution. To an extent, and can go through and make amendments to it later. If needed.
I think we're going to be seeing developers who are far different from any that we've seen so far.
I don't disagree with you on that, but I also think we're going to run into what Holly's talking about with the pressures from Columbus getting much stronger than they've been before. And so do we want to bog everything down so much in meetings that somebody says, to heck with Harlem Township, I'm just gonna go to Columbus? Or do we want to say, these are our standards, we're willing to work with you, but you gotta do what we want. And we'll try to move this along for you. And I think
at that point, if they see one thing that they don't like, they're still gonna go to Columbus or whoever.
none of us know. I guess there is that potential, but if we get to the point where they even look at this and they're like, oh my God, this is 17 meetings before I get anywhere and I can go right to Columbus. I think there's some sense in making this not necessarily an enjoyable process, but an easy enough process that people are willing to work with the township, especially if there is this JED component that gets us some tax revenue. You know, I think we want to try to make this work.
So Holly, do you want to write it up both ways?
Yeah,
with and without the zoning commission in the, as a requirement?
Okay.
In the,
No, I don't know that that's necessarily going to help.
well, it's not going to be the whole zoning commission, it'll be one or two members of the zoning commission.
But we already have one or two members of the
Yeah,
zoning
I-
commission.
But
and-
it's
And
a
I think
may
it really
instead of a
needs to
must.
be a preliminary meeting with the zoning commission. That
With-
is my,
The entire
My
zoning
view.
commission.
That's what
Preliminary.
what we're hearing from Joni is that she wants to
if
make a
nobody else does,
recommendation
fine, but that is
that
what I'm
this-
going to vote for.
that this be changed to include the preliminary meeting process that's been written into the PRCD. And Holly's already indicated that she acknowledged that for that type of conservation district, it's okay. But for this, she didn't see it as being appropriate. That's why it wasn't included. So.
Yes, it does take longer, but it also gives the public a chance to talk to the developers, express their opinions on things, and
But that's also misleading because if they meet the standards, you have to approve it, whether the public likes it or not. So a lot of places don't even like to extend that because residents then think that they have more of opinions to,
Yeah.
that they can add to that. And it's, if you meet the standards, it gets approved.
well, then I think we're gonna have to make the standards a lot tougher.
Well, with this particular paragraph, then what I thought Tom was suggesting was changing the wording, but not necessarily putting in that there would be a preliminary meeting with the zoning commission.
You can write it up both ways.
Can
in
we
the-
keep,
In draft two, and we can pull one out and, we can.
At some point, we're gonna, as a group, if we don't reach a consensus, we'll vote on whether to do it one way or the other.
Yeah.
can we
But I'm
leave
not
it as is
suggesting
for
you-
now and keep going so that we can?
Yes,
get
that's
to
just
the
what I was
stage
about to
so that
say.
If those are strong enough, then this is a,
Can we move
we
on?
don't need to argue.
I'd
Yeah.
like to move on.
Yeah.
So let's go on and deal with that as an issue at we'll be recessing at some point and we will be coming back on May the 1st. I would also like to see at that point what Delaware Regional Planning Commission is recommending in terms of if they are making any recommendations with regard to changes on this. And that could be an area where they would be addressing it as well. So we will come back to it. It's not a decision at this point. Going on, anything else on this page? All right, the next page. Application of development plan. The wording that we have somewhere else is prepare application and development plan. Is there any reason that it can't be worded the same way here? So the wording matches?
Sure, that's fine.
What page are you on?
It's number C.
Just a second.
letter C.
Well, I'm looking at. I have to pull up the one that,
Okay, there it is.
I was looking at the one that I worked on at home.
Yeah. That was different.
It's different, but it's item C.
Okay.
Yeah. Application development plan. That's just a simple wording thing.
Yep. We got it.
We're looking at it in terms of trying to be consistent
Yep.
with some other sections that we have in other, well, like in the PRCD. So that if we try to get some consistency, it just helps us. All right, anything on this page additional? Tom, you,
At
I don't know if you
the
mentioned this page or not. You said you had
yeah.
some things later.
C4, in the middle of that paragraph, which starts, the township zoning inspector reserves the right to request a third-party engineer. That's a repeat of number 2 on the first page. I think it's largely duplicated. I don't know that we need it twice.
Yeah.
Maybe there's something, it looks like the second time it's a little longer.
Yeah. And you and I went over some of those changes. We just didn't reflect them in this draft. They'll get reflected into draft 2.
That's
I didn't want to change it since we had already advertised the meeting.
And that's all I have on that page.
So for number 2 on that page at the top there, the top section, a grading plan usually designates a contour interval.
Okay, you're right. 2 feet or,
You choose
that
like
okay?
the feet around here.
Yep. can do that.
And if you're gonna do contour intervals, then going down to the bottom of the page, number 12, under D. Existing topography at a minimum 2-foot contour
Okay.
interval.
I would like you to have seen more in that number 12. More similarities to include things that were in section 1307 D3 in the PRCD. It just talks more about, I think, additional kinds of sensitive areas, and it includes historical
Okay,
features as well.
okay. And you said that was 1307 D3, just so I can refer back. Okay,
Pretty sure, unless we've been working on that. I don't know if it's been renumbered or not.
we can find it. I have what Scott,
In the
But-
PRCD.
Yeah. But it just includes additional types of natural and
What
cultural
number do you
features. Like
think it is? I can look it up here real quick.
1307 D3.
1307.
D does not have letters, so.
Oh. It's one we've been working on.
Either way, you've been working with Scott, you can probably find.
I can find it. You don't need to do
Let's
that
keep
tonight.
moving.
Yep.
Okay.
Okay.
Seven is. B is an on-site walkabout.
No, it's not B, it's E.
D. E,
Holly will find it.
all right.
Yep.
E, what happened? to-
Yeah, I'll find it, guys. It's okay.
All right. It's D, okay. A site survey with maps,
Yeah.
that's the paragraph.
Yeah,
Okay.
it included other things,
Yeah, it's in 1307 E.
Okay,
whatever. Don't know what happened to D on that page.
Okay, going on.
Page 3. Or whatever, what starts 13, 14, 15.
Mhm.
I'm still there.
yep, that's where I am.
At the end of 15, Detailed engineering is not required, where what we've talked about is pretty detailed engineering. So I would take that sentence out.
I can tell you that we have required detailed engineering in other places and the districts have not been successful. The overlay districts have not been successful. It is too much to get into detailed engineering at the zoning stage. And I feel that you could possibly run into some legal issues with that. I could talk to my legal counsel if you'd like, but I have been asked before to change that to preliminary and keep out detailed.
If you could find out why.
Yep.
That's the only thing I have on that page.
19, you talk about existing structures being demolished. And being labeled to be removed. This comes back to some of those structures possibly being historic structures. So I would add something like any building to be removed that's over 50 years old should have an Ohio Historic Inventory completed before removal. Because once it's gone, it can't be recorded.
We can do that.
Anything else on page 3? Page 4? Let me see here. I'm trying to figure out where this is exactly. Got a note here. I guess it goes with 37. The applicant may request a divergence from the development standards set forth in the mixed use overlay articles. I went back when I trying to find, maybe you will recall, within the Article 34, our density permitted uses, percent of open space excluded for divergences?
Correct. And if they're not all listed in the current version, they have been discussed as being, all those being added in
Okay,
the
because
next
that,
draft.
I think that should be in there.
Correct.
Okay,
We agree with you.
all right. I don't know that this needs to be here.
No, it has to be in the other
But it
section.
has to be somewhere,
Yep.
yeah. Okay.
Is there any place where things like TIS judge and NCAs and stuff are in the definitions?
You know, it's not a bad idea. We can do that. Yeah, that way people know what they are. I agree.
Under paragraph E, why are you specifying 30 days there? For us, the zoning commission to hold a hearing?
Typically, just to keep the process moving, I have pushed it down to 45 days before, if that helps you, since you meet on a monthly basis, if that gives you those extra few days to get the hearing scheduled, but we want to be able to be able to get something in and hear it at that next meeting. We don't want to be 60 days out scheduling
Yeah.
hearings.
No, I don't disagree with that.
Yeah,
Just looking for a little bit more flexibility.
I think the-
sometimes, since we only accept applications on the first Monday of our meeting, sometimes the next first Monday is gonna be maybe
More
a
than
little
30.
more.
right. So if we change that to 45, that would give you that flexibility. I
Yes,
think.
definitely it would.
Yeah, and I'm fine with that.
I don't want to complicate things too much, but we normally say 20 to 40 days.
We don't want to do that because that is for a rezoning. And if you're
Gotcha.
going to
Remember.
confuse people.
Yeah.
Yeah.
Thank you. I thought of that too, Tom, but then I thought, no, we don't want to
Mhm.
potentially confuse that.
Right.
So. See, the zoning commission shall make a recommendation to trustees and develop a plan within 30 days. That part down there, that 30 is okay.
Right. Right.
Oh, and then I do have a question about, the last paragraph for the trustees. Take action on said development plan at its next regularly scheduled meeting. They may want to do a special meeting. Is there a problem with that?
Trying to think if,
Because the next, well, for, as one example, it doesn't happen often, but it did happen this year. They moved a meeting, canceled a meeting, so then they didn't have another regularly scheduled meeting for 60 days.
mhm,
But they could have had a special meeting.
mhm. Okay, we can change it, I think. I don't see a problem with that.
You've got, under F, you've got basis of approval. We've used the language in the PRCD language criteria for approval.
Okay. We can do that.
Is it, yeah, I was just wondering, is there a reason? Okay, if
Yep.
they can match that, just better.
Yep, we can match your current. That's fine. Do you say criteria for approval or criteria
It's,
of
it
approval?
reads criteria, yeah, it's criteria for approval.
Or, that's what I was wondering. Okay.
Yeah, if there's nothing else on page 4, let's go on to 5. Anything on page 5? Oh, I see some red on your page.
10 is
have
not
it on
bold,
mine.
whereas the number, other numbers are. but that's-
Yeah, I don't think any of them are supposed to be bold, so we'll
And,
fix
and you're
that.
relettering everything.
Yeah,
anyway, so
exactly.
it's just not a huge deal.
No, I don't see anything that we need to take up.
Okay, Joni, did you have anything? That's on 5, okay, how about 6? Now, the new language that you gave us,
Mhm.
we, it's identified where it's going to be, but we didn't talk about it again as we
Correct.
went through.
Correct.
But you'll put this into.
We'll
our
put it
next
into the
draft.
next draft, correct?
So you talked about, I'm looking at A1 triple I.
Uh-huh.
You were saying, a couple of feet here and there,
Mhm.
and we make it 2 feet instead of 5.
Sure.
I mean, if
She said a couple, so you saw your window.
Yeah. I'd say 2 or 3. I can see why you wouldn't want to go to 5.
I mean, 5 is not a miss. 5 is they're trying to get something
Mhm.
that wasn't approved.
Yeah. Yeah.
2 or 3,
Yeah.
measuring error.
Yep.
Maybe.
Same with setback.
Setback, I'm not so,
Yeah, we have the buffers with the setbacks and stuff, so.
that's it.
I
Okay.
have a question on
I
A1
don't know.
4, the subsection 4.
Before we go on, are we going with 2 or 3?
Up to you, up to you.
An increase of no more than 3 feet.
3? Okay.
What is that? Was that game you play?
2.5.
Oh, the
Rock,
rock, scissors, paper.
Yeah.
Okay, all right. Sorry, Joni, I didn't mean to cut you off.
Okay, so, if the zoning inspector is in charge of the minor amendments, how can we handle that number 4 there under K1? Anyone aggrieved by the decision? Because that won't be a public meeting. That zoning inspector is going to be doing that in a non-public meeting with an applicant.
It's just like if somebody comes in to get a zoning permit and it doesn't, and the person doesn't agree with the decision of the zoning inspector, then it's aggrieved to the Board of Zoning Appeals. So this is treated like a zoning permit issue.
But nobody else, anyone who's aggrieved by that, they're not gonna know.
Anybody who's aggrieved by the decision of a zoning permit wouldn't know either. It's the same situation as a zoning inspector issuing a zoning permit.
Well, the applicant is going to know. Who else are you thinking of won't know?
Whoever's aggrieved by the decision. Neighbors,
Well, if they don't notice, it's
Well,
probably not bothering them.
you
They
know,
won't be aggrieved because they're not the ones who, the zoning inspector is making a decision.
they
maybe,
they
yeah.
can be aggrieved because they, if the encroachment of 5 feet or.
So we have to remember that all of this is an administrative act. These are not legislative acts. These are not legislative issues.
Mhm.
So therefore, when there is an administrative decision being taken place, that does not need to take place in a meeting. This has been reviewed by
I
legal
think if
counsel.
The setback is gonna be changed from, less than, or, 5 feet different or something, then a neighboring lot might be aggrieved by that.
I see what you're saying, yeah, as a concern.
Mm.
I don't know how. Is this kind of language that's been typically
It's
used?
language that's used throughout the state of Ohio and overlay districts. It's language that has been approved by our legal counsel.
Yep, I think if it's a big enough difference, somebody will notice and they'll talk to the zoning inspector. If they don't notice it, then
Are they gonna be within 30 days of the decision? I mean, if the action isn't taken within 30 days of the decision, then it's not gonna be noticed within 30 days of the decision.
But this is an encroachment. This is a done deal. This is something that's on the ground, so somebody will see it.
Well, the other thing is that we're putting it in as part of the zoning resolution. And in other words, it's there as a request can be made by anybody, by anyone who is pulling down the overlay. So if it meets the requirements, the zoning inspector basically would approve it unless the zoning
But this is a-
inspector says
this is
no.
This is an amendment.
a
Yeah, but
minor.
it's a minor amendment, and we've already said it's approvable. But if they're if it's,
So once the code establishes, it becomes an administrative act.
yeah,
So
This is
basically,
not
Joni, if we
legislative
want
act.
to change something, it's gotta be the number of feet that they're allowed to change on their setback or the height or something like that. Because that's where we have the control to change those things now. And if we're not changing those things, then
Mhm.
it's just administrative, so. If we're fine with everything else, then I
Okay.
don't think there's any point arguing about 4 because it's just administrative.
yeah. I think if there's an issue, that potentially if becomes a major amendment, then it comes to the zoning commission and we go through the whole process.
Yeah,
Okay.
Anything else on this last page? Okay. And before, now open it up to the public. You have any questions or comments about what we've just gone through? Mr. Steel Smith.
Yes, Joni, can you, we didn't get to hear some of your comments. We want some clarification as to what you said because we missed it. And it was on your definitions on the business retail. And you had asked, you had questioned some kind of businesses.
I specifically questioned a gun shop.
Okay, where you mean yes, no, what? You didn't want one?
I would prefer not to have one in an area that's gonna be this dense.
I say, and you didn't recommend any action on that?
Removing that word.
Yeah.
That would be my recommendation, is to remove that word.
Okay, and then nobody did anything? Did you take the word gun shop out?
yeah.
Okay, then the other thing, was on, is I had to step out and make a phone call. I'm really sorry. Was Holly going to make up on the meetings? Was she going to make up an alternative to this so you could discuss it? Is that what you came up with?
For the pre-application meeting,
Yes.
she was going to generate some kind of an alternative.
All right, so you're gonna have an alternative to discuss.
Yes.
Okay, thank you. I'm just trying to get up to speed.
So that we will have that, and then we didn't reach a decision,
Okay,
but we will
okay.
on May 1st, because we're going to
Right, right.
recess
I'm
this
sorry, I had to go out
hearing
and-
to May 1st.
Township business, I had to go out.
Yeah.
But just wanted to get us up to date where we're.
No,
at.
that's
Okay,
fine. I'm glad you're asking, so
Okay,
we get
thank you.
clarification.
Okay.
Other questions or comments before we recess this hearing and go to the next one? Yes,
This is the said district. Where is the said district that this applies to?
well, that's going to be the next hearing.
Okay.
What we have just dealt with is just the procedures. And we haven't talked about specifically where it's going to be, but under Article 34, there's a specific area, and we will be discussing that,
Okay.
yes. When we open that hearing.
My understanding of this procedure, once it is approved, and it's been mentioned several times here. The requirements of this procedure just need to be met, and there's really no other, once this is approved, there's no other vote, there's no other, I mean, it's. Once this is approved,
We as a zoning commission would still look at it. Determine that it does in fact meet these standards or doesn't. And approve or deny them pulling down that overlay at that point in time.
Recommend.
Recommend that the trustees.
We
approve
would,
The
it.
trustees still have a final vote on it.
we would have the hearing on from the applicant that's interested in pulling down the overlay district. If they pull it down and submit the application, as Virginia's just explaining, we would hold a hearing, we would review it, and we'll make a recommendation, Tom's just saying, to the trustees. The trustees then would take the final action. If they approve it, there is no referendum possible on it. The appeal would go to common pleas court. If there's someone who does not agree with the trustees' decision.
but do the trustees have power to not approve, even if it meets all of the requirements?
We we determine whether we believe it meets all the requirements, and then we make our recommendation to the trustees. The trustees make the final decision to approve it or not. If they decide not to, then they can vote yes to approve our recommendation. They can modify our recommendation, or they can deny the application. And if they deny the application, the applicant can appeal it to court. Same as the public could appeal it to court.
There are also 10 criteria for approving it in addition to the standards. So you meet the standards, you also have to meet the 10 criteria. Do you have adequate water, adequate sewer? Do you have the proper funding package, drainage? So there are a number of criteria that have to be met. So it's not a slam dunk. It just is an administrative act versus a legislative act. That's all I'm saying.
Yes, and those are all the things that the zoning commission will consider as they make a determination of whether or not it meets the criteria.
So, who is Crossroads representing?
Crossroads is simply a consulting firm. She can tell you about her
Who's hired?
company, but the trustees have hired her to work with the strategic planning committee to develop these recommendations. There were 10 meetings that were held with the public. And what is being considered in terms of the areas and the changes that are being made, not the specific requirements that we're reviewing now, but the general conceptual ideas were reviewed at 10 meetings, and the proposed changes in terms of creating these overlay districts were discussed in each of those 10 public meetings. And what we're dealing with now are articles that have been created to implement the recommendations that were made to the public and were discussed with the public in those 10 meetings. Correct, Holly? Am I stating that very?
We worked on the plan from March of last year to February of this year.
Yeah. And the plan was adopted
In
February.
March, at the beginning of March.
So I don't know, I may be in the wrong meeting. This is just setting up on how a development plan comes in and it goes through the process, correct? So there is no major development plan that they're going through. I mean, it's imminent, it's coming. But this is just a set procedure on how somebody applies, correct?
The next hearing,
So
which
there's
will start when we finish with this one, we'll go over more specifics for what could be developed in the area that's being discussed. But right now, it's just sort of the administrative side of how a developer would come in and present something.
It'll have the standards, all the architectural and all the standards a developer would have to meet. So we're not developers. We're
Right.
writing the zoning code to help them
Right.
control development when it comes this way.
Well, and again,
There, at the
there's-
present time, no, there's no specific development.
Because this
That is
specific
being
district
brought
also
forward.
requires sewer access, which we do not yet have.
Right.
It's coming, but it's not there yet. So
Well, we've
even
got
if
electric
this,
lines going right down the road here. right
yes,
Across my property, so that's a great thing that I'm very happy about in this area, so.
I mean, they're already through my backyard. It's,
Well, they weren't 5 years ago when I bought the lot and built my house.
You're saying they are, but they are now. Where
They're gonna be really close. There's two options. It's either gonna be 300 yards this way or 100 yards this way from my house. And I'm livid. So that's why I'm here. That's part of why I'm here. Plus, I don't want to take a Knowles property across the road. He has 294 acres and selling it to, and have half acre homes in there either. So that's another thing that scares me about the development. That's, and again, I'm not saying that my house is worth more than anybody else's, but I moved to the country to be in the country. And I'm, not saying I'm gonna move. I'm just saying that, now we have no choice except A or B. And of course, we're going to the meetings for, American Electric Power, and they're gonna put on their 9-person dog and pony show. And we'll all clap and smile and they'll feed us whatever, but bullshit's what they're to my way. That's what they're gonna feed us, because it's gonna go in no matter what we do. We just have to find the best,
And the township has no say in that
I
either.
understand that. I understand. I'm just trying to find out.
and the
I didn't
power,
pay attention last year and there's a distillery going next to my house. Because I didn't pay attention. A retail distributor, a retail distillery is going next to my house and I'm not pleased. So I'm either gonna not complain about it or I'm gonna come and educate myself in these meetings and find out what I can do.
But that was voted on.
I know,
The township voted that in.
I know, but there has to be some kind of a zoning variance for somebody to take a residential house and put a distillery, a retail where people, they're not drinking it there, but they're having tastings and selling. And a
They have
retail
not
establishment.
applied, they have not applied for a variance.
As long as it operates,
That's what, excuse me, sir, that's.
as
actually
long as
why-
it operates under an agricultural
That's what I'm trying to.
provision, there's nothing the township can do about it.
Well, not putting it in that
That's what they did.
Pole barn.
Beg your pardon?
I think that's what they
Right.
did.
That is what they did.
and I think your best option is to come to these meetings. And I've said that to every member of the public who've had at meetings all along. Please come, please make sure you're educated because we're also residents of the township. We want what's best for everyone too. And we want all of you to know what we're trying to do that is best for everyone instead of just looking online, listening to this, that, or the next thing. We're trying to work with you.
I can't complain unless I get involved. So that's exactly why.
All right, well, at this point, let's recess this
I
hearing
have one more question on this.
on this specific
this-
procedure.
yeah.
Sure, go ahead.
So I've heard a couple times tonight, if it's. We risk annexation, I think you made some comments, and I'm sorry, I don't know your name,
Virginia,
Virginia.
yes.
We want this. Why, what is the risk of annexation and?
Columbus coming in and having a more desirable offer to whoever chooses to develop that land. And then we as a township basically have no say over it and they can kind of do what they want.
That
So
will be
there is a-
unincorporated land, correct?
Correct. There is,
However, does it
We have
incorporate that land into
Go
Harlem?
back over what
there
you
is a 1 hour video.
spent the last
It is
6 months
a
doing.
video of what covered the 10 meetings that we had to educate the residents of this township. That was recorded and is on, is it still on your website?
Yes.
It is still on the Harlem Township website. It'll tell you why annexation is a threat, what annexation is, and how easy it is for property owners to annex and take away the land out of the township. So rather than try to go through all of that 1 hour tonight during this hearing, I highly recommend that you watch that video.
Then if we have questions, are we allowed to ask at the next meeting?
Sure.
You'll
Yes,
approve
there
our
will be,
questions as long
there'll
as
be
we
an
have-
opportunity for public participation at each of our meetings. But what she's just referred you to is a quick strategy guide, which is what the strategic planning committee worked and developed
Well, so
first.
I just built my house, so I wasn't even here till a couple months ago. so
Okay.
I can't be blamed
But-
for not being at your meetings last year. right?
That quick strategy guide is available online, and you can see all the recommendations that are the basis upon which these articles, which we're now considering, have been developed. And the next article we're going to deal with is the first one that is actually designating an area of the township and the type of development that can occur in that area. Now, there was one other person that hand up. Yes.
Really quick, you were talking about the criteria of the developer having financial resources. Excuse me, is the HOA, are you looking for that? Is that part of that?
So what we are looking at is for the mixed use, which is commercial and mixture of residential and commercial, would be in a JED, which is a joint economic
Okay.
development district.
All right, well, let's recess this hearing to date and time certain. The date will be May the 1st.
You want to call out the time?
I beg your
You want to call out the time?
pardon?
It's
Yes,
8:52.
once we decide on doing it.
No, currently it's 8:52.
No, I know, but we need to announce it when we do it.
Okay, let's do it.
That's what I mean.
We already have a hearing set on May the 1st at 7:45.
Yes.
So this would have to be after that.
Is that the her shed?
Yeah.
So I think maybe we should, what do you think, 8 or 8:15?
Hershey's not going to take long.
I don't think his.
Hershey, I don't think will take long. No, I don't. think
Yeah.
it will. We can do 8 o'clock.
That's fine.
All right, so we're going to, at 8:53, we're recessing the hearing on Article 31 to May 1st at 8 PM. Okay. With that hearing in recess, then we will need to open the hearing on Article 34, mixed use districts. And with that, Mike, would you again call the roll, please?
Mike Kavler,
Here.
Jody Manson,
Here.
Samuel,
Here.
Virginia Lewis,
Here.
Tom Need,
Here.
and Brittany is not here.
All right, the hearing for Article 34 mixed use district is now in session. And with that, Holly, let's go back to you again and we'll go through the process that we did with the first article.
Thank you very much. So the mixed use district is the area, and we'll get to the map here in a second, but it is the areas on the southern end of the township along Fancher Road. And again, this is created pursuant to section 519.021C of the Ohio Revised Code. And the first section just outlines the purpose to provide an appropriate mix of uses, to create diversity in housing options, to create walkable communities and a sense of place, to provide accessible open space recreational areas, and to create design characteristics that integrate into the surrounding area. Also to create unified development projects. Again, this would require water and sewer connectivity for future development. And it helps protect the southern area from Harlem Township from annexation going back to the quick strategy guide and the reasons why we're concerned with annexation. This overlay, again, is along the southern border of the township. So if you can see my mouse, this is the south township border. And this is Fancher Road, right in here. Get my mouse to go up there. Right here is Fancher Road. This is Harlem Road. And over here, this over here is South County Line Road. So the south side of Fancher Road, between Harlem and South County Line would be part of this overlay district.
Right there.
And then
That's just gonna minimize.
right around Green Cook Road, it bumps up so that it would be on
That's
both
everybody.
sides of Fancher Road. And then it goes up South County Line Road. Again, this area has been identified due to concerns with incoming sewers and nearby communities with potential threat to annex quickly into this area. So this would provide a zoning option for developers to pull down the cloud and to create something that is desirable within the township rather than what another community might have for this area. So it's setting the design standards for the township and planning for development, you controlling development and letting instead of development controlling the township. So the effect of the MU overlay district, this just goes back to the procedures where it says that when you this cloud is pulled down, that action is a ministerial act and it is administrative and only pursuant to an appeal under chapter 2506 of the Ohio Revised Code. The permitted uses within this district are mixed use buildings, which are buildings with residential on the top upper levels, and then either retail or office uses on the first floor. Common wall, single family attached dwellings are also permitted, which that's just another term for duplexes, 2-3 family, multifamily buildings, multifamily dwellings being defined as 4 units and above are also permitted up to 12 units per acre in sub area B, is that right? A, thank you, sub area A,
I thought it was the other way around.
which is the westernmost part, and then
It's 12 units in B. And 8 in A.
Yeah, B is the dark blue,
Okay,
at least according to the map.
we need to switch those numbers then. So it should be, it's 8 as you go east, and it's 12 on the western side. So we will make that change. Nursing homes, independent senior living facilities, and assisted living facilities are permitted. Retail stores, small or medium, large are not permitted. Eating and drinking facilities, wineries, microbreweries, including those with curbside and pickup windows. Park, recreation and community centers, office facilities, those include real estate offices, law offices, medical offices, and the sorts. Veterinary offices, pet grooming, as long as the facility is fully enclosed by 4 solid walls and a roof. Early childhood education, elementary, high school, and technical schools are allowed, as well as service building and structures incidental to a permitted use. Then we talk about prohibited uses. Anything that is not specifically listed as a permitted use is prohibited. Outdoor storage is also prohibited, as well as the storage of semi-tractors or unused vehicles and trailers. No trailer, boat, motorhome, or any equipment of the similar nature shall be stored in front of the established building line. And then no mobile home or mobile office shall be placed or occupied in the district. And then there's language regarding trash, debris, and unused and discarded materials being prohibited and not create an eyesore as determined by the Board of Trustees. And that would be enforced under section 505 of the Ohio Revised Code, which is the nuisance law. No commercial activities or business activity shall be conducted inside a dwelling unit except for home occupations. So you can run, a home office out of the dwelling unit, but you cannot be running a retail store out of your home. No outside storage of any kind shall be permitted unless it's complete, it has to be within a completely enclosed building. No drive-throughs are permitted. This includes banks, restaurants, coffee shops, and other similar uses. We're trying to create a walkable community in this district. We do allow pickup windows and curbside pickup. And if you go to the definition, that is where you order ahead on an app and pick up. There is no ordering and waiting and queuing in those lines. No automobile-oriented uses shall be permitted. So no oil changing facilities, car washes, anything that requires you to not get out of your car to have a service provided. Those are all prohibited. There shall be no data centers or warehousing and no large retail permitted. The district shall follow the procedures that we just reviewed in Article 31. The minimum lot size, or excuse me, not lot size, the minimum tract size shall be 25 acres. So what this means, and we heard a lot during our 10 community meetings, is somebody that owns a 5-acre lot just can't come and pull down the cloud and develop their 5-acre lot. This is meant for a more comprehensive development, something on a larger scale. So you have to have at least 25 acres to pull down the cloud. You can still subdivide that and have 5-acre lots or however many lots you want under that if you meet the minimum lot size, but the overall cohesive development needs to be at least 25 acres. There is a 20% gross, 20% of the gross tract acreage must be required open space. Then there are site design standards, again, to try to create that unified development and design approach. We do say that these standards supersede anything else in the zoning code. So everything should be following these standards and nothing else. That's why we've included everything from signs to landscaping to parking within these. And then the bulk area and setback requirements are also outlined in here. This just talks about preserving and replanting native vegetation adjacent to wetlands and surface waters, preserving hedgerows and tree lines unless there's dead and dying trees, protecting wildlife habitat, especially those that are protected under ODNR, preserving historic and architectural sites. So even though we didn't mention it in the procedure section, we do talk about it in the actual standards, retaining and planting vegetation in common areas, and then also including pedestrian circulation systems with walking paths and bikeways throughout the developments. And then again, protecting natural drainage swales and creeks, and no construction within the 100-year floodplain. So this is where the 12 units per acre and the 8 units per acre are listed, and we'll make sure that they're corresponding to the correct sections. The density shall be calculated on the net developable acres, and net developable shall be the gross acreage minus land that's being that cannot be developed, such as existing right-of-ways and a significant feature such as steep slopes, floodplains, and significant tree stands. So you would subtract that out and then calculate your density. This is where sewage disposal is where it talks about having central water and sewer of in order to pull down the cloud. Stormwater requires a stormwater management plan. This is where we are talking about utilizing regional detention ponds instead of every individual lot having their own detention. Looking at it from a more regional approach, utilizing soft edges instead of the hard scapes around those detention ponds, and having more of a natural effect when you're looking out on the site. The subdivision standards, public streets and all drainage improvements shall conform to the subdivision standards of the county. Private roads shall if they're part of the plan, they still shall meet the minimum width and pavement types. Pavement standards for parking lots, we have a minimum standard, to make sure that that they're not throwing on just a thin, layer of asphalt, but making sure that, there is, sufficient parking areas, for the type of uses that are being proposed. Paths, 5-foot asphalt walking path or a 10-foot multi-use path is required, to meander, through and create more of a rural character instead of being just lying down the existing proposed roadways. So having that meander, is something that is required in here. Street trees are required as well. And then, an existing tree lines must be preserved and a 200-foot woodland buffer must be established from the proposed right-of-way of an existing township, county, or state road. For this purposes, we've actually defined what the proposed right-of-way is because we don't have those right now in, the areas. We know that growth is coming. So we're saying that the buffer should start 75 feet from the center line of State Route 605. And then 50 feet from Harlem, Gorsuch, Robin Roads, and Green Cook Roads. We actually need to add some roads in here. When we were talking about the conservation district the other night, there are some roads that need to be added in both of those. The 75-foot, we need to add County Line Road, and then the 50-foot, we need to add, I think it was
Miller Paul,
Miller Paw, right?
maybe Red Bank.
And Red Bank. So we'll be adding those in there. All other roads are 30 feet. And the reason why we want to do this is because when we're establishing that woodland buffer, we don't want to have somebody come in and establish that and then with their development, and then the road need to be widened later, and then some of that get taken out. So if you start that woodland buffer where the ultimate right of way would be.
Did you mention Fancher?
Fancher should be the 75-foot from center line.
Yeah.
Yeah. Yep.
And of course, Gorsuch and Robbins don't even fall in the MU district.
Correct. But we have it in there in case anything would ever change in the future too. The 200-foot buffer shall consist of a minimum of 40 feet in width of native vegetative and vegetation and trees, and shall mimic the natural condition of the forest edge. This helps reduce noise pollution and creates a visual impact of the development from the township or county road. This is an image of what we're trying to establish. So this would be the road over here. And then this would be your 200-foot buffer. So you would have natural prairie land meadow type grasses, and then that would go into your woodland edge type plantings, and then into your actual woodland development. And then all of your development would happen behind this 200-foot landscaped woodland buffer. This just provides the different types of trees that are allowed within the buffer. And then this talks about how many trees are required within that buffer for every 100 lineal feet of frontage along the roadway. And then this graphic gives you the potential layout of how those could be planted. We talked a lot about mounds during the quick strategy guide and how we didn't necessarily want suburban style mounds. But there are times when the existing grading may lend itself to having some kind of berm. So we did allow a berm with a 3-to-1 slope, provided that the natural plantings continue along that berm and protect the adjacent roadway from the view of the development. These are the bulk and area requirements. Again, the minimum tract size is 25 acres. The minimum lot size is 1 acre, so they can subdivide it down into 1 acre lots for the different types of uses. Minimum setback from a collector road is 200 feet. And then that would also be the arterial roads. And then from a local road, 30 feet. The rear setback is 25 feet and 15 feet for the two different sub areas, as well as the side setback. But we also have an asterisk, because there are some additional, prairie buffer requirements, and I'll get to those in a minute. So if you are abutting an existing single family house, there's some additional, buffering that you have to do, in addition to those 25 and 15-foot setback. And we'll get to that in a minute. The maximum height of the buildings are 45 feet, and that's to allow for those mixture of uses. You need that 45-foot height to, create mixed-use buildings. If it's a single-use building, so you're creating what Joni was referring to before, a mixture of uses, but not necessarily a mixed-use building. So you have single-use buildings combined on a property. Those buildings can only be 35 feet in height. The only way we're letting it go up to 45 feet is if there's mixed use within that building. And then driveways and set, from side yard lot lines are 2 feet. Maximum lot coverage is 80%. And then I want to point out the asterisks, next to the building height. That corresponds down here that, the building height is measured at the highest point of the roof from the established building pad grade, as shown, on the approved grading plan. And then also, I believe we should allow the utilities to, the mechanicals to be hidden behind those, parapet walls as well. Dwelling unit floor area. So when you have a mixed use building or you have a single use multifamily building, these are the minimum dwelling unit sizes for studio 1, 2, and 3 bedroom units. And then we get into the design. Building materials and designs have to have a 360-foot finish on, so one, as you move around the entire building, it has to have the same architectural features and designs and materials. And then we have gone through a series of visioning activities with the strategic planning committee, and with we talked about architecture during the community meetings, and we came up with the architectural type themes that are desired by the community, and we have provided the inspirational pictures to show what those would look like, and what this zoning commission should be looking for when deciding if a proposed development meets or does not meet the criteria. These are the materials that are required to be on all of our mixed-use buildings. 80% have to be wood, fiber cement, board and batten, brick or native or cultured stone. Brick or stone can be used as accent materials as long as they don't exceed 20% of the gross exterior building wall square footage. Vinyl and aluminum are prohibited except for trim details such as downspouts, soffits, gutters, and shutters. Building colors need to be earth tones, limited browns, tans, and grays. Some colors may consist of white and barn red. Leaf greens and gray sky blues may also be used as accents, but it shall not be the predominant colors. When designing the buildings, they cannot have blank walls. There has to be a minimum of 3 design elements per 100 feet of elevation. Facing the public right of way, and a minimum of 2 design elements for every 100 feet when facing a side or rear lot line. And those design elements include wood columns, porticos, windows, trellises, patios, awnings, different street furniture, those sorts of things. And again, we give inspirational pictures of what those could look like. Flat roofs are prohibited, and there has to be a minimum of 6 to 12 pitch for the roof. They have to be constructed of dimensional shingles, standing seam metal, slate, or simulated slate. And I believe we've added HIP back into the conversation, so that needs to be added in. But gable, gambrel, and mansard roofs are permitted. Lighting plans shall be submitted as part of the final development plan. There are exemptions for holiday lights and street lighting and emergency lighting. There's also prohibited lighting such as searchlights, beacons, lasers, etc. Fixtures have to be the cutoff type, except for decorative light fixtures. The fixtures cannot exceed 12 feet in height. And we are adding in language because this was something with the CRCD that came in later, so that the height is measured from the established grade to the highest point of the fixture. And we have an illustration that we will be adding into this as well. The 12 foot of height is for residential uses, and then in commercial areas, 20 feet is the maximum height. In no case shall the fixture height exceed the height of the building. So if you have a smaller building, you need to lower your lights. Color temperature is a maximum of 3000 Kelvin. And that's a more blue or warm white type light. And then we talk about the lumens, and then we start talking about the foot candles at the property lines. So this is when property is abutting a single family lot. They cannot exceed 0.3 foot candles, which is a standard practice in commercial developments. And then at other lot lines for other uses, 1.0 foot candles measured at the lot line. And in the procedure section, they were required to give you a photometric plan that will show what those foot candles are, so that you can ensure that that is being complied with. This is just talking about dark spots. Lighting shall be directed towards the ground. All non-essential outdoor lighting shall be turned off after business hours, or reduced at least by 50% of the original lighting levels. These are more inspirational photos of the different types of architecture. Landscaping is required to establish a rural design theme. Landscaping materials shall be installed to provide minimum of 50% winter opacity and 70% summer opacity. Different types of standards have to be met regarding the types of trees and materials. Talking about landscaping not being within the street site triangle to ensure that we're establishing safety when we're at our intersections. And then parking lot screening. All parking lots have to have at least a 36-inch continuous planting hedge tree combination, or a decorative wall with a fence in conjunction with the landscaping, which is what the picture is showing, or a decorative planter with lattice or other similar design, which is the other picture down to the bottom left. The height of the screening shall be measured from the elevation of the adjacent parking area to the top of the screening material, and all native species must be used. There's also requirements for parking island landscaping, and also requiring a tree within each of the parking lot islands that's required. Landscaping between lot lines. This is where I was talking about if a lot abutted another, the commercial lot, a mixed use lot, abuts a lot with an existing single family house on it. If that single family house is within 100 feet of the abutting lot line, then there has to be a minimum of 200-foot woodland buffer that complies with the woodland buffer requirements that I discussed up at the top. If the existing single family structure is more than 100 feet from the abutting lot line, then they still have to provide a 100-foot prairie buffer, which we show down below, and I'll talk about that in just a minute. If there's no existing single family structure on the adjacent lot, it might be zoned for residential, but there is no existing at the time that development came in, then no buffer is required along that lot line. And then, so where the prairie buffer is required, this is the amount of trees that are required per 100 linear foot adjacent to the existing single family lot. Then we talk about parking access, parking lot locations, parking lot sizes, drive aisle width. Parking bays, we do require that each parking area does not contain more than 24 spaces, so that's 12 rows. on double-sided. So 24 spaces, and then it has to have an island, 24 spaces, island. So that you're breaking up the asphalt, sea of asphalt, and creating landscaping within your parking lots. It has to be screened, which we already covered above, and we just referenced that section above. Then we get into the minimum parking spaces, and there's actually a minimum and a maximum for the different types of uses, because we're really trying to cut down on the amount of pavement. So we don't want having these large seas of asphalt of parking that nobody uses except for maybe on a holiday, but rarely even then as well. Access is limited to those approved by the county engineer along county roads. ODOT went along State Route 605, and on township roads, there shall be at least 200 feet between access points. Vehicular connectivity, there needs to be connectivity between the properties. So if there's a mixed use going in, they should be providing a stub into the next property, or butting their property, their parking drive aisle up to that lot line, so the next one can connect into it. And that's where that connectivity memo comes in with the Delaware County Engineer's Office. They'll be looking for that kind of stuff to make sure that those connection points are being made. And then we get into signs. We want again to have that rural design theme. So signs need to be stone, wood, or brick, at least for 80%. The fonts and colors should align with the rural character, and they really should match the overall architecture of the primary building. So that's again, that's a decision that you would have to make as a zoning commission, and then as the trustees, are they meeting that standard or are they not? So there is some subjectivity in there, but if they, you have to say if they meet that standard or not. And then mixed use buildings are allowed to have projecting signs, which are the ones that you, these are projecting signs that you can walk under, and you create more of a walkable area. Mixed use buildings can also have wall signs and ground mounted signs. And there's different size requirements based upon the different types of signs. You can also have canopy signs, which are over the doors of buildings. And then temporary signs as well. Window signs are also permitted. Utilities must be buried underground. And then the zoning commission can determine if additional measures are needed for buffers, existing land uses, to buffer existing land uses. So you do have the ability to add some additional conditions regarding that. And then this talks about the divergences. And this is where we're going to make sure open space, density, and land uses are specifically referenced within these areas, that they cannot be considered divergences, that would actually be a rezoning if they want to alter those three things. And that's it.
All right. Thank you. One of the things that I was anxious to get this started, so I forgot to read the public notice that was published in the Dispatch in order to make it a part of the record. And I will do that now. I looked it up, got it on my phone. This is the public notice regarding this hearing for Article 34 that was published in the Delaware Gazette. The Harlem Township Zoning Commission is being asked to consider the following. The Harlem Township Strategic Planning Committee is requesting that the Harlem Township Zoning Commission consider amending the Harlem Township zoning resolution to include a new zoning article. They are recommending that a new article 34 mixed use districts (MU) closed be adopted as part of the Harlem Township zoning resolution. Proposed Article 34 mixed use overlay districts and with the overlay definitions are identified as being available online, and there's a hot link for those. The hearing will be held on Monday, April 24th at 8 p.m., but we started late at the Harlem Township Firehouse, 3883 South State Route 605, Galena, Ohio. The hearing is open to the public. Proposed article can be viewed by appointment only. Please contact the zoning office between 8 and 12, 8 a.m. and 12 p.m. at 740-965-2661 extension 2. The zoning hearing will be also available on Zoom. The link for the Zoom meeting is identified. That's the posting that was in the Delaware Gazette. That will become a part of the record. All right, with that said, let's get back to now taking a look at this mixed use district. As before, the zoning commission will begin the process of going through this. I want to make sure that we have the opportunity for the public to comment. So if we can't get through the whole document tonight, we'll take a break at that. Well, it's already what, 9:25?
25, yeah.
So I don't know how quickly or how many issues there are that folks may have with the zoning resolution, but let's at least start. We'll spend about 10 minutes. And then I'll want to open it up to the public to see if they have questions or comments.
So first thing, I know we had talked last time about having mixed use and then overlay district. Does the next copy has that been noted already? Okay,
Adding the word overlay in there.
yeah, mixed use. On that first page as well, H protects the southern area of Harlem Township from annexation. I guess I'm hesitant to say protects because it is still a possibility.
Sure,
But
sure.
it helps to protect.
Let's add the word helps to.
Okay.
protect.
I just don't want
Yeah,
us to get
I
into
agree.
a legal issue of
Yeah.
like, you said you could protect it. You can't. Go ahead.
Just as a general comment regarding the outline again in terms of the numbering, this article has most of the numbering that matches with ours, but there are places where it needs to be
Yeah.
adjusted to bring that into line.
Sure.
And you'll see that as you go through it. The headings are start with the number, then the capital letter, then the Arabic numeral, then the small letter, then the small lowercase Roman
Yep.
numbering. That's the steps in terms of setting it up. So any places where that's not in place, if you would make those corrections, that would be greatly
We
appreciated.
will do that.
Okay, anything on page 1? Anyone wants to comment about? Page 2. I wanted to suggest inserting the word overlay after in that well, it would be the second paragraph. The end of the sentence says MU district, insert the word overlay in between, since we're
I
putting.
think anywhere it
anywhere.
says MU district, which there were ones on the previous
And we
page too.
wanted to make sure we're emphasizing that this is an
Yeah,
overlay.
yeah.
And we did talk with the map about borders or boundaries. I can't remember what we
Yes.
decided. So on page 2, I get, my only question is whether we're going to consider changing the map format to one that's more like
Yes, we are.
this, where we have a better look at the
Yes.
actual parcel.
Correct. We are working on that.
Okay,
We'll have that in the next draft.
that's a
In,
yes.
in that same vein, there are a lot of the drawings and stuff that you've included in many cases are kind of blurry. And I don't think it's just my eyes, although my eyes are not good. But places like your sign stuff, and there were some other things I noticed as we were going through. The things that are photographs are pretty clear, but the things that are closer to drawings are less clear.
The drawings are prepared by an architect in Revit and exported as images, so there's really not much I can do with that.
There's gotta be a better. I mean, so some of these are quite difficult to read. And I found that true on the online one as well. If you blow them up, they're still blurry.
Can we just say, in general, try to make sure we have as high of resolution pictures as possible and then
Again,
keep going?
yep.
Page 3.
Page,
Oh, wait a minute, on page 2. And this is more for the zoning commission. When we approve things, we often refer to, conforming to the intent of the comprehensive plan. And the comprehensive plan isn't mentioned in here at all.
That's because this again is not a legislative action. So we are, when we adopt this as a whole, we are adopting it as in accordance with the comprehensive plan quick strategy guide. But once this goes into effect, this is administrative, not legislative.
Interesting.
We already are identifying that the overlay district is in compliance or in
Correct.
conformance with the master plan, so there's not necessarily any reason then to recite.
Exactly.
The
And in
master
fact,
plan.
yeah, we don't want to do that for legal purposes. We don't want to be.
Right,
Because it's not a legislative action.
that makes sense, because what we're dealing with is already something that we've determined meets the requirements of the master plan, and that's why we're adopting it. Okay.
But individual applications don't have to meet the intent of the
They have to meet
master plan.
these requirements, which you were saying, these are requirements are in accordance with your master plan.
If they meet these requirements, then they meet the requirements or the guidelines of the master plan. That's because it's an overlay district.
One question on the end of page 2, page 3. The distinction between permitted uses and prohibited uses, which is important because permitted uses, because a divergence cannot change a permitted use.
Correct.
And what we've got here is in the permitted uses, we have wording like such as or any other like, or things like that, which give you some flexibility. But in the prohibited uses under A, it says uses not specifically authorized by the express terms of this article are prohibited. So how does that one, on the one hand, express terms, and on the other, such as and like, how do you decide what's what?
Yeah, I let us work on that. I don't, let us work on addressing that for you.
You could go with uses not specifically authorized as permitted uses.
Yeah.
Of this article.
I like that.
are-
Mhm.
So you still have some flexibility
Yep.
in if it's
Yeah.
not actually spelled out, but
Yep.
it's close enough.
Correct, yep.
And I did have a question. Do all developments have to have a mix of uses, or can they all be like apartment buildings?
We do
Or-
not provide a minimum mixture requirement. It's what they call that sometimes when you say so many have to be residential, so many have to be commercial. We don't provide that in here because communities that have required that in the past have run into issues with how do you assemble that mixture? Because different developers do different things and they don't always work in teams together. But when they come in, you end up having the mixture of uses by default by allowing those different ones throughout. If that makes sense to you.
And I think well, specifically in part C there, we need to be much more specific on which is B and which is A. When you're talking about numbers of dwelling units per acre.
Yeah.
And are there any other places where we want to differentiate between A and B?
well, so E, number of dwelling units, this is page 5.
Mhm.
We start with 12 units, which is B, and then we do 8 units, which is A. It seems odd that B comes before A.
We'll just switch it.
And so I don't know if we can like just unify everything.
Yep.
A comes first, it's 8, becomes second, it's 12.
Very literal.
I mean,
No.
I have other things on 5, if we can move on to 5.
All right, we're still on page 3. Did anyone else have anything else on 3? All right, then page 4.
Under F, I think you already picked up limited home occupation.
We've talked about that, correct.
Okay, I guess it's just a question I have on H. I'm not sure I understand why pickup windows aren't considered drive-throughs.
You talked about no queuing of cars. It's preventing the line of cars wrapping around the building.
But if you have a pickup window, aren't they gonna drive up and pick it up?
Yeah, but if you've ordered ahead of time, there's less of a
Oh,
backup.
there's still a backup. At Starbucks there is.
Well, but some people at Starbucks are ordering it
Starbucks, yeah.
in the line.
Yeah, Starbucks would not qualify as a pickup window.
I think someplace we need to be more clear on what a pickup window is then.
It's in the
It's in the
definition section.
definitions.
Yeah,
Um,
the only
yeah.
thing I saw about it was automobile oriented uses.
No, there's actual pickup window definition, and it talks about requiring a digital app to
okay.
order ahead of time. It's on page 3 of the definitions. A window used to pick up an order placed ahead of time online via web or mobile device, not to be used to place orders.
Do you think you're gonna force people out of their cars? I'm all for it. I'm just.
Yeah, Donato's has a pickup window. I've been there to pick up a pizza and have had to wait in line because there are multiple people getting them. So I think that's kind of what Junie's expressing. potential concern about.
But
Yeah,
it does
I still see a
reduce the
difference.
level.
Well, and we're
It's
gonna
not-
have
it's
sewer
not the same
10 years
thing, I
from this.
like-
When we get to sewer, there will be robots making everything and it'll all go perfectly. So no way.
But it moves quickly as opposed to having somebody sitting there and taking an order.
Exactly.
Page 5.
Anything else on 4?
No.
Nope, page 5.
Number 4, the first one, a majority of trees are dead, diseased, or dying. Can we add invasive in there? Because I don't want to prevent somebody from removing invasives. Also on F, second sentence or second line, and the applicant shall provide a feasibility letter shall be provided. I don't think we need both the shall provide from there.
Yeah, I'd like to see them remove those pear trees.
You're gonna have to go out with a chainsaw on your own.
Like there's too many now.
So on page 6, for street trees, can we add native?
Yes.
I'm just gonna keep going until somebody tells me they got something
Keep
else.
going.
Page 7,
Do we
No,
have,
no, hang
do we have
on.
any information on what the subdivision standards for Delaware County are? Do you know what those are?
They're online under Delaware County Regional Planning Commission.
Okay, anything else on page 5? Page 6. We've already identified that we need to add Fancher, but I think you were aware of that.
I'm sorry.
Under L, we need to add Fancher.
Yes.
It's one of the major roads that's in
Yep.
that MU district.
Yeah, right.
What would we do if by happy circumstance, Delaware County engineer says we're gonna use a thoroughfare plan and build a road that doesn't exist there,
And do what?
and build a road that doesn't now exist? along the
So
county line?
you have size or like arterial connectors and.
yeah,
that's
so
stated.
so it would be from the right of way line of whatever that road is. I only define what the proposed right of way is when we don't have a right of way established.
I'm not saying they're ever gonna do that.
Right, but you never know. I know.
Okay, page 7. I think Virginia had some
Yes.
things on 7.
Can we add something to the effect of any other trees added to an undesirable list? I don't know if that's ODNR or who puts that out. Can we also prohibit some shrubs like honeysuckle
Well,
and other invasive?
specify Japanese honeysuckle,
Yes,
because the
yes.
native is fine.
Yes,
So also, this is kind of a combination here on 6 and the old 7. When you're talking about the 200-foot buffer has to have a minimum of 40 feet of native vegetation and trees.
Mhm.
Well, there's what's in the other 160 feet?
So refer down to that drawing. So the first 40 feet is the native, the meadowland woodland, and then you get into the actual woodland where it's required to have the actual larger trees. And then if you go over to page 7, it gives you the table that says the number of large trees, number of small trees, and number of shrubs that have to be in that area.
And it covers 100 lineal feet.
So every 100 lineal feet, they have to provide that. So if the lot's 200 feet long, they're providing double that.
Are you good on 7?
I guess this photo or drawing here,
That one,
that one, that is from one side to the other, is that 200 feet
it is,
or 400?
that is
40?
not, it's not to scale, but that is to represent 200 feet.
Okay,
correct.
so that would be the whole 200
Correct,
feet. And the
yes.
first 40 feet would only be like this part.
Correct, yes. The meadowlands going into the woodland edge. So what's called the woodland buffer.
Given the time that it is, I would like to, at this point, break and ask and provide the opportunity for public to ask questions or to make any comments at this stage. We're not going to obviously take any action tonight. We are going to recess this hearing as well to May the 1st, but want to open it up for public comment at this point.
Can we see the mixed use map again?
Mhm.
The southernmost point you said was the boundary and then up to Fancher, or Fancher is the southernmost boundary?
So the southern boundary,
this one too, because it's that easier to see properly.
Yes, nice.
so this is the township southern boundary. So that is
Okay.
the boundary, southern boundary of the MU. This is Fancher Road. So at the south side of Fancher to the south side of the township is the mixed use area until you get to Green Cook area. Just west of Green Cook, it pops up and then goes over so that it covers both sides of Fancher Road over to South County Line Road.
What's the northern on the top there? Once it goes east to Green Cook, what does it go up to there?
Evans,
And then across to County Line?
you're talking about Evans Road is the top of that L shape? Is that what?
Not the very top, but the second tier that goes up, what is that northern?
That's just the
Yes.
back of the property lines that front on Fancher Road.
Okay. Thank you.
Any other questions from the public, comments?
So this is the mixed use district. Are there other districts that are
In the
being
works?
proposed?
Yes. There will be other overlay districts that'll be coming. The Strategic Planning Committee is working on them. Right now, they've got, well, Holly, I'll let you speak to them because
Yeah,
you
so
are,
right now we're working on the clustered conservation residential, which would be to the north of this area. And it would be where the 50% of the land is retained as open space, the other 50% is clustered residential. so that it maintains this density, the same density across the whole thing, but it's clustered on 50% of the land. And then eventually we'll be working on a center village overlay district as well. And that all aligns with the quick strategy guide that the trustees adopted in March.
When you say Center Village project,
Mm-hmm.
you're talking about a residential area on Center Village.
It'll probably be mixed use, allowing residential and to maintain the commercial corridor through.
Center Village where?
It's the Center Village Road, 605, and there's certain boundaries. If you look on the quick strategy guide.
East towards like Green Cook and County Line?
Not
It
that far.
doesn't go
Not
quite
that
that far, no.
Great. Oh, yeah, that's real close. Great. This,
But when you say, this clustered. So today it's what, one house, 5 acres? Right, I mean, that's what most of that area is.
Most of this area is smaller, actually.
Acre lots. So when it's clustered, we're allowing up to 2 to 3 dwelling units per acre, but clustered on. But again, that's not for tonight's discussion. That's for, when we get to that.
Yeah.
public hearing.
There are others, and that's one of the other areas that will be forthcoming, but we're not going to have discussion about it tonight simply because we don't have a recommendation yet from strategic planning. If you want to get more specific information about what's going on with strategic planning as they are finalizing their recommendations on clustered, then go to their meetings. They meet on
First and third Tuesday of every month. At 6:30,
in this room.
right here.
What are some of the things that are looked at when you're figuring out what is gonna be district or what these districts are? Do you look at the age of the homes that are in the area, the number of homes for sale, or just the access of the accessibility of the area, or what's used to determine where these districts are?
We went through a whole analysis of how Chandler, Arizona developed when Kinsell
Yeah.
went in, and we also talked to real estate professionals out there of what they did, what they liked, what they didn't like, what they'd like to see different. They suggested more service, commercial, closer to the Intel area, which is why we're putting more mixed use down towards the Intel area. And then
Where was that feedback coming
from past experiences of Chandler, Arizona professionals.
resident are horrible for Chandler, what it did to them in the beginning.
Yeah.
I mean, it grew too fast, it buried them in a lot of ways. So, we're facing that here. We know we are. So
We're trying to push
Yeah.
forward.
Yeah, but there's not residential feedback in this stage of it, correct? When you're deciding where the zones are.
Oh, we went through a series of 10 meetings with the community that provided feedback to us
Okay.
throughout that.
For this area, for example.
There was an online feedback and also I got a card.
Yeah, there was a survey. Yeah. Yep, we had a
Did
meeting in
surveys.
August last year at the church. We had several different public meetings.
You were talking about the Center Village project.
The public meetings have already happened for the districts as a whole. That was all part of this quick strategy guide. One of these meetings will happen when we do the Center Village one.
How will we be aware of that? Again, I'm
The-
self-employed, I travel a lot, I work a ton of hours. How-
HarlemTWP.com. HarlemTWP.com is the
Okay.
township's website.
Okay.
All the notices, public notices are posted there. If you happen to get the Delaware Gazette, unlikely, it's there.
I can't read.
And it's also posted on the back door of the firehouse here. And there are some not legal next door Facebook, social media postings that occasionally happen, but I would not rely on those.
So there's not like an email that you can join if you got on the Harlem TWP.
Well, if you
No.
get,
No.
actually, you can give us your email address and we'll add you to this
Distribution list.
strategic planning committee's email distribution list.
I'm
The re-
finding
the recommend,
Facebook.
Yeah.
Better than coming from Harlem Township.
I realize it's not sanctioned, but it is much more accessible to people. It seems.
there is a Harlem
And-
Township
and-
Facebook page as
Yeah,
well.
that's- I'm getting information on the meetings from that that is better than the Harlem Township.
Well,
I
there-
used to look at the Harlem Township all the time to find out minutes, and it's like the minutes are just so slow coming into that site.
Well, we have, the township does have a newer administrative assistant and the website is being revamped. We understand that there's some hiccups, but we're trying to get them sorted out. There-
Your emails to you? Do we do it through the website or can we give them to you tonight?
Whenever,
Your
You can give
email
them to-
address, just
Okay.
write it out for me.
whenever there's going to be a public hearing regarding any of the new districts that are going to be proposed for consideration, there will be a public notice of that posted on the township website. So anytime that we post it, it will be posted so that it will give you an absolute minimum of 10 days prior notice. That'll be on the website. But typically, it's up anywhere from 20 to 30 days prior to the scheduled hearing. So if you check the website periodically, just look for the public notices and see if there's a new posting for another district that will be under consideration. Right now, we don't have any others that are being considered. But potentially, the CCRD that was just mentioned, that may be coming to the zoning commission, and when we do receive it, then there will be a posting at a future date when we will be considering or scheduling a hearing to discuss that one, just like we had these hearings for tonight.
And we also schedule all of our hearings at our meetings. So if you just keep coming, you'll always know.
Yeah.
Will there be obviously, a lot of us are concerned about the EEP project.
There's
A lot of us are concerned about the EEP project. Are there going to be special hearings? For
We
that?
have, the township has no impact on
Is that right?
AP,
Okay.
none, zero.
All I can
You
tell you
talk to
is,
the Ohio Power Sighting
Yeah, no,
Board.
we have, there's a couple there. Like Dave said, a couple dog and pony shows coming up, so we'll be sure to get. to
Yeah,
that.
and
So
they've
we-
already, yeah.
we have the big ones through our backyard, so do our neighbors. All I can tell you is the longer you hold out, the more money you get. So.
Don't want money, you just want to go away.
I don't think they're going to, so you might as well get a nice vacation out of it. My parents gave up too quickly and my neighbors got more, so.
But there's, actually, I don't think they're paying attention, the northern long-eared bat and the great brown-eared bat is actually here local, and I think that's gonna be a problem for them.
And if,
It's not gonna make it a problem.
yeah, I was gonna say, if you can get them information, I mean, tree trimming companies are not allowed to cut during certain times of the year because of bats.
Our son is an environmental scientist.
You just told us.
He told us about the bats that we need.
My mom is a professor of environmental science at Ohio State.
Although I do have a Japanese spotted turtle, but that's different.
Are there any member of the public that is participating via Zoom? Does anyone out there have a question or a comment that you want to share with the zoning commission tonight? If so, you have to unmute yourself to speak. Apparently not. Okay, just wanted to make sure that the folks that were on Zoom knew that the opportunity was there.
One thing, Mike.
Oh, yeah, Keith, I'm sorry. I meant to introduce you before we started the hearing. Keith Campbell is a member of the Board of Zoning Appeals. He happens to be participating tonight as a member of the public.
But they're not posting on the back door anymore because they don't have enough space. And so they're doing by appointments. You have to call the township.
Oh,
Administrative make a-
what's posted there is the fact that it is available and you have to make the appointment. Yeah, you can't post the whole thing out there.
They
It's just a posting that it's available.
It's so large, there's just not enough room. It used to be, but each. hearing-
Can we get a QR code that takes you right to the website so you can see it on your phone? Is that too much to ask?
Yeah, it's too
I
much
think
to
that's
ask.
Starbucks, aren't you?
Too expensive.
But anyways.
All right. Any other questions or comments tonight? Given the,
Oh, Mike, can I
Go
just
ahead.
ask Keith a question since he brought it up? Do you know? We used to send a copy to the local libraries
yeah.
for these sorts of things? Are we not doing that anymore?
Doesn't the library get a copy of the Gazette?
It's 10 o'clock.
So in a roundabout way, they're getting it that way.
No, we used to actually send a copy of articles that were,
Oh,
We mean the actual zoning code.
The other one's 8, so we
Yeah.
said this one for 8.
I don't know if the library has them or not. It is, if you go to the BZA part of the Harlem Township website, the whole zoning code's on there.
Yeah.
You can open up, you can see our whole resolution. I know. I don't know that the libraries have it or not.
The zoning, I go to Delaware County Regional Planning Commission land use page
that is.
and all the
All the
township, zoning, all 18 townships have the zoning resolution.
I wouldn't trust the libraries keeping anything current.
No, but yeah, I do know that it's my easiest go to just go on the township website, go to the BCA section. It says Harlem
But I mean,
resolution right there. and
When we were making changes to the zoning resolution, we used to send a copy of the changes under discussion to libraries so that they could be viewed there for people who can't come between 12 and noon here. And there are most people are going to be working between 12 and noon on a weekday.
Since we.
The whole. These sorts of things that we're discussing tonight.
I'm reading them tonight as you're going through.
Okay.
Oh, yeah, there's a hot link on the website. All you have to do is click
Okay.
on it and it'll take you to the document.
Your suggestion of the QR code is actually a really good one. That will make that a lot. Trying to find things, especially as we start to lose our vision and figure get clumsy, it's worth it. The QR codes are really convenient. You just take a picture of it and it takes you right to whatever article you're looking for. So instead of having a big list of things going on, you just have a couple QR codes for whatever.
like I said, we've got some hiccups as far as technology is concerned, but
Well,
maybe.
I don't know why it's difficult. It's just a hot link. You click on it and it goes directly to it.
Well,
So what's the issue? No, I'm serious. I'm
Mine
just
doesn't
trying to
come up.
figure.
When I hit that hot link, I just get a blank.
Yeah.
I just get a white
And-
page. I can't see anything.
I personally find that, like, I know what the BZA does, I know what the zoning commission does, but if I were a member of the public and BZA meant nothing to me, it was just a bunch of letters, I would find it a little challenging to figure out where I needed to go for what.
With the new internet site that has just been put out there, it's a piece of cake. It's very well organized.
Just go to public notices.
I'm good. I'm just.
Find everything.
Well, if we're gonna put it on the door,
Yeah, that's
I can see a QR code potentially being very
Yeah,
effective
so it's right
and helpful
here.
there. I'm just talking about what's on the website.
No, yeah, that's.
Yeah.
When you-
So I haven't looked at the website, I've only looked at the mobile version,
Don't look at that.
and, well, but this is what I usually have with me, so when I'm sitting in a meeting,
That's very effective. Need a bigger screen.
Well, I accessed it tonight on my phone,
And I
so
did
it is
too.
definitely there.
yes.
But it's really clumsier.
And so that is, I understand the website is getting better, but the mobile site is something that a lot of township residents will be looking at, so that also needs to get better. That's,
It's there, you have to manipulate it.
Okay.
yeah.
Well,
I'm
we're
not
not,
saying-
let's not spend any more time discussing that. We'll have to work on that in the zoning office. Mr.
Can I
King-
ask a question?
So Mike, you're hearing the
You have a
discussion
Question.
and see if you can't address that within the office itself and with the administration office. Did you say someone's on
Yes.
Zoom wanting to speak?
Yeah, this is Matt Bryant on Fancher Road. I know it's late. Should I ask about extending the boundary next on May 1st? When we
Oh,
have more time?
You can, yes,
what'd you say, Tom? Sorry, I
Yes.
didn't hear you.
yes.
The response basically is yes, Matt, because of the time at this point, we will be recessing to May the 1st. And I would definitely recommend that you attend either in person, it'd be preferable for you to be in person, but if you can't be here, fine, do it on Zoom. And we will be responsive to whatever questions you may have.
Sounds good. Thank you.
All right, thank you.
This, we're gonna recess this to,
Yes, we're going to look to recess now. Let's set us, well, we're going to be May 1st. Now we have to select a time. And we're recessing shortly here. It's 9:59 now. So we recess to May 1st, 8:30.
8:30.
It only gives you a half an hour for.
We're gonna recess it to May 1st at 8:30, but it may start later. Depending on how long it takes us to finish with Article 31.
That's it.
Okay, with that, our hearing Article 34. Mixed use overlay district is now in recess until May 1st at 8:30. Thank you all for coming. Please come back.
Do you have to reconvene regular meeting and then,
We never even opened.
Never
a
had a
regular-
hearing. Oh, that's, we only did hearings tonight.
so we don't even have.
We don't have to adjourn.
We have to-
We
Not
we
adjourning
recess.
because
go.
We're recessed.
You're free. Except you told a bunch of people you'd collect
I
dates, so
said,
you're not
not
free yet.
schedule a meeting because I didn't think we were gonna have time to do anything.
Yeah, we get it.
So I think we do probably need to. Open a regular meeting on May 1st.
Oh, we do, yeah, because it is. a
Your name?
My name's Brian.
And then we also have that application.
Yeah.
We have another hearing at
Christian.
7:45.
Yes. Yes.
Begun to look at that. application.
I made it through these things, but.
Well, and yeah, I know exactly what you mean. Looking at the first page, the application.
I saw the first page already.
Yes, we do.
Thank you very much.
So you'll be on the
The parcel,
strategic
the
planning
parcel
committee
that's
distribution
identified
list.
already. and, FR1 zoning.
Good, thank you.
Parcel that he wants to change, just the 5 acre parcels. He's got the 3.49 acre parcel,
Alrighty.
so
See you all.
And that was one that was advertised then.
that's the one that's at.
Anybody end this?
Because that was his application.
1 week from now, maybe 2 weeks.
I talked to Mike and